Good day, everyone, and welcome to another interesting class on PUL341, Topic 5. Today, we shall continue our topic on defenses in criminal responsibility. What are some of those defenses that are there for the accused person that has been charged for a crime or for an offense? We've looked at some defenses in the past, like accidents. We've also looked at self defense. We've looked at immaturity. And of course, we've looked at bona fide claim of right of the accused, of a defense that's also available to the accused person. Today, we shall go further to look at other defenses, and we shall be looking at insanity. Um, Under what, how does it avail an accused person? We shall also be looking at insane delusions, and of course, we shall also be looking at mistake of fact. And if time permits, we shall definitely be looking at one or more other defenses available to the accused person. I am Dr. Alera Akujobi, your facilitator for this class. So welcome, and let's start the day. Thank you. Welcome to another interesting day on Criminal Law 1, PUL 341. Today we are on to topic 5, and we shall be looking at more of defenses for the accused person for criminal responsibility. Today the defense we shall be looking at is the defense of insanity. Defense of insanity. How does this help as a defense to an accused person? Does it lead to a total discharge and acquittal if the accused person is able to raise it or not? This we shall see. But before then, let us understand what we mean by insanity. Insanity is a form of mental disorder, a state of unsoundness of the mind. And a person in such a state is usually unable to control and appreciate his actions. And such a person normally is said to be non-composed mental, that is not sound in mind. Now, like we said, it is more of a state of unsoundness of the mind. The term, again, is more or less synonymous with mental illness. The important thing is that it negatives the individual legal responsibility or capacity. So, what is the effect of insanity on an accused person charged with criminal responsibility? The effect is that it negatives the individual's legal responsibility or capacity. Now, insanity under the common law is based on the rules formulated by the judges in the celebrated case of Magneton. This case basically had to do with a deluded paranoid, one Edmond, one Robert, one deluded paranoid called Daniel Magneton, who shot and killed the secretary Edmond Drummond of Sir Robert Pell, thinking that he was Sir Robert Pell, and he was subsequently tried for the murder of Drummond. But he raised the defense that he was not he did not know what he was doing, and that he was always having a delusion that others were pursuing him and wanted to kill him. The judge gave their verdict of not guilty on grounds of insanity. Of course, this generated a lot of public outcry that the matter was taken up by the House of Lords, and then the judges came up with the question, give an opinion on the question of the nature and extent of unsoundness of mind in the commission of the crime of the sort complained of. He was held not guilty on grounds of insanity. Now, going by the Magneton rule, again, every man is presumed to be insane and possess sufficient degree of reason to be responsible for his crime until the contrary is proved. Now, what the Magneton rule normally looks at to establish a defense of insanity is that at the time of committing the offense, it must be proved that the accused person was laboring under a defect of reason from disease of the mind, or not to know the nature and quality of the mind he was doing, or if he did know, that he did not know that it was wrong to do so. So the important thing to look at for that is the nature and quality of the act. Two, did the accused know that what he was doing was wrong or not? So these are some of the things that is necessary when considering the accused nature, whether it's responsible for the act or is not responsible. So again, This whole magnetic rule also had a lot of criticisms that followed it, as over the years various criticisms were made in respect of the rule. Some pointed out, particularly psychiatrists, that there are many mentally ill people who do not able to appreciate intellectually that an act might be wrong. Nevertheless, were under intolerable emotional pressure to commit it. In other words, they were paranoid. That is, even though they were able to know that this particular act they are about to do is wrong, but all the same, because of that intolerable emotional pressure on them, they still commit the act. And then the view of such people is that to describe such people as responsible was a fiction of an undesirable kind. That again was explained in the case of Durham and United States. Now, another criticism again is that of burden of proof. Remember, as we said in past, in matters of insanity, the burden of proof, unlike in other issues that is on the prosecution, this time it's on the accused person. Now, the contention is that if a rational person is, for instance, not burdened with the defense of provocation, mistake, self-defense, and all of that, even for a rational person, you do not tell him to prove such a thing. The proof is on prosecution. Why then the burden of proving insanity on an accused person, especially when he is hardly able to directly discharge the burden? So these are some of the criticisms that have followed uh, this Magneton rule. Okay, but in spite of this criticism, the Magneton rule formed the basis of insanity, the defense of insanity under the Nigerian law. Now, under the Nigerian law, we have a defense in Section 27 and Section 28 of the Criminal Code and Section 51 of the Penal Code. And also the case of R and Omoni is very instructive here, where the court was of the view that for insanity to be established, it must be proved that the mental disease or the natural mental infirmity, as the case may be, was such that at the relevant time the prisoner was, as a result, deprived of the capacity to understand what he was doing or to control his action or to know that he ought not to do the act or make the omission. Now, in Nigeria, the primary, the first limb of the defense of the first limb of Section 28 of the Criminal Code is on the defense of insanity, while the second limb is mainly on the defense of insane delusion. Now, it is necessary to understand that it is immaterial that the person was capable of distinguishing between right and wrong, or fully aware of the nature and quality of his act. But as a result of a disease that he was suffering from, he is unable to resist acting in the manner he did. So this is what we said before, that the fact that he knew what he was doing or not is not really the issue on ground, but that because of what he was suffering from, he could not uh, resist the impulse. He could not be able to act otherwise on what he did. Now, Section 229 of the Criminal Procedure Act relates to acquittal for insanity. Normally, when a person has been found guilty of the offense of insanity, what is the position? Is he discharged and acquitted? No. And then, so that section is relates to acquittal on the grounds of insanity and enjoins the trial court upon such acquittal to state in the findings, actually whether the defendant committed a crime. It is necessary to confine him. Basically, of course, the object of confining him is to protect the public from such persons and their propensities, and is normally sent to a mental home where it should be suitably looked after. However, where a person is insane and criminally inclined, it makes no difference whether he has incapacity or where his incapacity to understand what he's doing or wrong, that he ought not to do or control his act. So the position is that a person who stabs because he's so insane is not to know that he ought not to stab, should be confined, and yet a person who stabs because he cannot control his action should be left at the danger of the public. So a distinction is kind of being made here about insanity and people who do things because for who do things as a result of impulse. So the position now is that why do you confine one and then the other one is now being left to move around after evidence has been proved that he was not, that he could not, evidence has been proved and he could not exclude the insanity of uncontrollable impulse from the uncontrollable impulse. So that is one issue or one argument that has been put forward by a lot of persons. Now, still under insanity, like we said, the important thing here is that under the defense of insanity, you must be able to establish that you did not know what you were doing, and that even if you knew what you were doing, you could not control your acts, and even if apart from that, that you also had no capacity to control your actions. So these are some of the things that must be established for the proof of insanity to to um, to avail an accused person. So, although no one can cause his own insanity, in order to use the disease to camouflage premeditated murder, scientific knowledge can go back to reconstruct a background of self-induced insanity, as in Shola and the state, where the lower court refused to accept the evidence of insanity, where the accused killed his own mother and explained why he did so. There was, however, medical evidence that he suffered from catatonic schizophrenia at one time or the other. But according to the trial judge, it can hardly be denied that the accused did not had not stimulated his own matricide plan by having a smoke of Indian hemp, to which he had by that time become an addict. However, the Supreme Court, on the balance of probability, found that the applicant had no capacity to control his action and was not guilty of murder by reason of insanity. Now, if we go further, we will see that Oputa JSC, as it then was of the opinion that what is relevant is the state of mental disease and not of the accused person. What was his state at that time and not what caused the state. So, if he was in a state of mental disease such that he could not control his action, whether that mental disease was brought upon by smoking of Indian hemp becomes irrelevant. So, that is what the court is after. Again, in some cases, like the case of Ihore and the state, where the accused person wants to rely on witchcraft or that is following a particular belief, that will not hold, as a personal belief is not usually on trial in criminal matters. Having talked about Section 28, the first limb of Section 28 that deals with insanity, the second limb is on insane delusion. Here, the accused person can raise the defense of insane delusion if he can show that he was at the time of the offense affected by delusions in some specific matters. In other words, that to that extent, he was not criminally responsible to the same extent as if the fact believed to be true were actually true. So for him to prove insane delusion, he must be able to establish the fact that, that at the time of the offense, he was affected by in some specific matter that he thought were true, that he believed to be true. In Aaron Grumman, insane delusion was defined as a system of mental disturbance and a false belief which is unshakable by facts. So it is a symptom of mental disturbance and a false disbelief which is unshakable by facts. So I think this is one of the difference between insane delusion and mistake of fact. Why one arises as a symptom of mental disturbance, the other one could be applicable to anybody as a mistake of facts generally. So quite unlike the defense of insanity, the accused is liable to the extent of the imagined false belief. That is when it is insane delusion. So, like we said, delusion arises when there's unshakable belief which exists only in the imagination of the patients. So, like in the case of Yesifo and the state, Wanyawo and the state, where the appellant suffered from delusions which induced him or which he felt was driving him that the disease should send evil spirit to kill him at night. That the disease whom he killed would send evil spirit to kill him, the accused, at night. So what he now did was that he now waited for the disease and killed the disease. so that it wouldn't be the other way around. So basically, in proof of insanity, what are those things that the court must look out for? One is that insanity can be established by testimony of relations, of friends, or family. You know, this kind of evidence has been shown to be relied upon by the court wholly and exclusively, as in the case of R and A. And also, insanity can exonerate the accused person where it is shown by medical evidence or psychiatric and other competent person. Such evidence too can also be relied on by the accused, by the court. History also of past, history of the accused person is also could also be relevant. Medical history could also be relevant. Evidence from prison wardens who had custody of the accused and who looked after him are also some of the things that can become relevant to the court when in matters of insanity. So there are many cases on insanity. Sanusi and the state, Nabo and the state, Onyekwe and the state, and so many other cases. What is important here is that if you take any law report or on insanity and you want to read it, you will find most of these cases there. All the factors that must be established for the defense to avail the accused person are all normally there. You will also see the distinction being made between section 20, first limb of section 28 and the second limb of section 28. So these are all that you need to know of insanity. And also important to know that the defense of insanity could be relevant at the time of the commission of the offense, at the trial, at the time of trial, and even before execution of a judgment. So it could be brought in at any time, either during the commission of the offense, at the trial, or even before execution. So these are all things that you should know. And like we said, the defense is on the accused person. It's not on the prosecution as in other instances. So this we can see under section 141, subsection 3 of the Evidence Act, section 139(2) of the Evidence Act. Also, another section that is very important in this insanity cases are section 36, subsection 5 of the Constitution, and also section 27 of the Criminal Code, that is to the effect that everybody is presumed sane until the contrary is proved. So, what are the consequences of a finding of insanity? Basically, that the accused person will be discharged. I mean, will be acquitted, but definitely not discharged. As he will be put in a confinement until on the pleasure of the governor or president, as the case may be. So again, let's briefly look at insane delusion and mistakes of fact. What are the similarities and differences? Similarity between the defense of insane delusion and mistake of fact is that in both the state of things erroneously believed is true that would have been justified at that would have justified the accused alleged act or mission. But so is that whether mistake of fact or delusion, insane delusion, there's an erroneous belief as a state of things. Okay, so the fact is that if those state of things were actually as the accused person were actually true, would the accused person be justified in his acts? So that's basically the main difference between the main similarity between the two of them. However, the differences are that insane delusion deals with the question of partial insanity due to some abnormality. Remember the definition we saw the other time that it has to do with some mental disease, some abnormality or defect in the brain that leads to such lead to such where for mistake of fact normally it affects perfectly normal persons. Everybody could be guilty of mistake of fact. Again, another difference is that insane delusions are usually of a persecutory nature on some specific matter or matters. Like we saw where one believes that he's been after, he's been pursued, he's been tortured, he's been this, and if he does not do so and so, something might happen. But then the court will look at it exclusively in the sense that if really this state of things were true, will you be justified in your act? So that's basically for insane delusion and mistake of facts. There are similarities and differences. Again, briefly, what is automatism? Automatism is normally recognized as a defense in criminal responsibility. See that in Bratty and Attorney General for Northern Ireland. So normally it means an act which is done by the muscles without any control by the mind, such as reflex actions, spasm, convulsion. An act done by a person who is not conscious of what he's doing. Such an act could like sleepwalking while you are convulsing, or even somebody suffering from epilepsy. Reflex actions. So something that you have no control over, and in the process you commit an offense. It will be deemed that you could be entitled you could raise the defense of automatism in order to escape liability. The rationale for this defense again is that the accused person or the defendant is not responsible for the consequences of his action. So basically, from what we have just said, automatism arises from unwilled act. So to that section is normally linked to section 24 of the criminal code. So and we also have insane automatism and non-insane automatism. Insane automatism is very close to is very much like insanity in itself. Also, what also has to be established is proof of mental disease, and then also that the accused person the they know that he ought not to do the act or make the omission, and he could not control his action. So these are the things that must be proved in non-insane, in insane automatism. Again, we have non-insane automatism. Non-insane automatism is automatism that is normally brought about by self-induced acts or omissions, where as a result of you know what you are doing, for instance, taking overdose of insulin and all of that, and having taken overdose of it, you now start to react and all of that. So what normally happens is that for such acts or for such accused person relying on such defenses, e.g. from intoxication or whatever, so it does not normally negate the mens rea necessary for crimes of basic intent because the conduct of the accused is restless. So non-insane automatically does not act as a discharge or as a defense to criminal responsibility, while insane automatically does act as a defense. So while insane automatism will be treated as insanity, non-insane automatically, the accused person will be treated as guilty for the particular offense. So again, is the fact that in some cases, whether insane or non-insane automatic cannot be pleaded in the alternate. That you cannot say it is either this or it is either that. In the context of the Nigerian criminal law, this view seems doubtful because the defense of insane automatism is under Section 28, while that of non-insane is under Section 24. Both defenses are equally open to an accused person who is able to adduce evidence in support of either. So either of the two, but not you cannot plead in the alternative. So finally, the questions here for you are that with the aid of authority, you have to determine the factors necessary to establish insanity of an accused person. Of course, going by Section 28, Section 27 to 28 of the Criminal Code, Section 51 of the Penal Code, Section 36 of Section 5, Sections 139, 140, and 141 of the Evidence Act, and its numerous cases on insanity. This all will enable you to determine the factors, which are that lack of capacity to control your actions, willingness to understand what you are doing, whether wrong or right, and of course, the presence of natural mental infirmity in the accused person. So these are all factors that must be established, that must be proved for for the defense to avail an accused person. Again, also the next question there, the defense of insane and non-insane automatism cannot be pleaded in the alternative. We've answered that before, that you can either plead one and not the two because they are both they both do not lead to the same result. So that's where we'll stop today. Thank you for your time.